Good morning, and thank you for joining me on the Path to Liberty. It's Monday, September 21st, 2020. I hope you had a great weekend, and I'm really grateful for you spending some of your Monday with me today. I hope your week is off to a good start. On this episode, I'm going to be talking with you about the Supreme Court. And no, I'm not going to do the political drama that you're probably hearing or watching or reading about basically everywhere else. He said this and they said that, and a few years ago they did this and that. I'm not going to talk about nominees or any of the political process. What I'm talking about is a bigger underlying issue we face no matter who's on the Supreme Court, and that is the legal doctrine of stare decisis. In essence, precedent holding weight over the Constitution itself. I've got some interesting insight from Randy Barnett, who's a great constitutional scholar, Elon Werman, and Raoul Berger, and how it's used as a tool to, in essence, legislate from the bench, and maybe how it could be actually used in an originalist method. First of all, before getting to that, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. Our show homepage is where you can find everything you need to follow the show. All the podcast platforms we're on: iTunes, Spotify, Stitcher, Podbean, iHeart, TuneIn, all that stuff. Plus all the video platforms like YouTube, DLive, Periscope, Library, Twitch, and on and on. You can find all of the episodes we've done for over 2 years. On individual episodes, I include a ton of links. I've got a bunch of references for you guys to read and learn more because I'm just scratching the surface. You can also find our membership program where you can put your financial faith behind our work for as little as $2 a month. All that information and more over at 10thamendmentcenter.com/path to liberty, all spelled out. Again, 10thamendmentcenter.com/path to liberty. Want to say a quick hello to everyone out in the live chat. I'm very grateful for you spending some time with me right now. Good morning from San Antonio, Bob Landry, MRGF78, sup. Tim Martin in Casa Grande, Arizona, pro-life, pro-liberty in Austin. Got a lot of Texans here. That's pretty cool. Lawrence Smith from Charlie West, Dan Warsaw, Melissa Harrell, Patricia Dance, good to see you. W.C. Blum in Ohio. I apologize if I get your name wrong, W.C. Maybe we can figure out how you get me pronouncing that properly. Sabalytic, Bob Brewer, and everyone else. I apologize if I miss anyone. But let's get right to this. And I want to start out by citing Randy Barnett. And Barnett has done a lot of great work. There's Dale Peterson in Omaha. Just saw that pop up as well. And Austin Thomas from the People's Republic of Ohio. Well, hello from my country, the People's Republic of California as well. Let's go right to Randy Barnett to kick this off with a quick overview of what stare decisis is. He says this is the doctrine that a court should rule the way a previous court ruled, even when the judges of the second court disagree with the earlier ruling. That bears repeating because I don't think I said it well. Stare decisis is the doctrine that a court should rule the way a previous court ruled, even when the judges of the second court disagree with the earlier ruling. I could actually expand that and really say, and in essence, that it really is a great way to put it. But it's the doctrine that precedent holds weight sometimes even when it's obvious that the judges think that the precedent violate the Constitution. So it, in essence, is putting precedent over the supreme law of the land, which they all take an oath to. That is the Constitution itself. Barnett puts it this way. He's got it right. This doctrine poses an obvious problem for an original judge or justice. I mean, it is right in our face. If the precedent is more important, even when you disagree with it, that is a serious problem. How can you be a constitutionalist? How can you follow your oath if you're told to violate your oath? He says, if a previous judicial decision reached an outcome contrary to what the original meaning of the Constitution requires, the originalist judge or justice is bound to rule contrary to that original meaning. In this way, the doctrine of stare decisis puts the rule provided by previous judges above the rule provided by the text of the Constitution. And that is a serious problem. And in fact, we published an article by Mike Meharry this morning talking about how so many people are going to get caught up with who, when, how, all this stuff, when the fact of the matter is anybody they put out there is addicted and committed to this doctrine of precedent, stare decisis. Next up from Barnett, he says there are really two types of stare decisis. And he says this is kind of a working draft of a paper where he's recommending ways to be originalist even within this constraining doctrine that is forced upon all judges and justices out there. And he goes through two types, and this is pretty common, something that I really have not covered, so very helpful that he put it in such clear language. I will link to this. It's at lawliberty.org. I will link to his article in the show notes after the live broadcast is done. He says there are two types. There's vertical stare decisis and horizontal. And this is a little geeky for everybody, but hopefully this will be pretty clear. He says vertical stare decisis concerns the precedential effect of a higher court's decision on a lower court. So vertical, if you think in manufacturing, some companies out there have a vertical system where they basically own the entire supply chain, for example. That's a kind of a Japanese style of business, for example. And others, they work with outsiders. Vertical means that there's a higher court with a precedent telling the lower courts you have to follow that precedent. He says no one doubts that the supremacy of the Supreme Court requires lower courts to honor the directives of the court in a case on which the court has ruled, and I hate the word ruling, they've issued an opinion. He says, but so too does it require courts to decide future cases with similar facts in the same way, even if the lower court judge believes that the Supreme Court's previous decision was inconsistent with the original public meaning of the constitutional text. And therein lies the problem with how this has been applied, how it is used in practice. And oftentimes, and we're going to get to this in a little bit moment, it's really used as an excuse to continue violating the Constitution. Well, so-and-so said this in this opinion in 1985, so therefore that is precedent. And, I may have some problems with what's going on, but I have to follow that precedent, however broad we want to look at it. And that'll be a term that we'll cover here in a moment. Barnett goes on. He says, by the same token, though, and this is an interesting kind of reverse way of looking at it, too. He says, inferior court judges who reject originalism, and there are a lot of them, so lower court judges who don't like the original Constitution, they are now actually required to adhere to outcomes dictated by Supreme Court originalist precedents. Now, there are few and far between, really. But on the positive end, if the Supreme Court was filled with a bunch of good people, and maybe that's the argument that they're making, if you fill it with a bunch of originalists, then it'll create this precedent thing. And I think that's putting too much power and too much concern over the fate of the Constitution and liberty in the hands of 9 elected, unaccountable, politically connected lawyers wearing dresses. Anyways, going further, that's vertical stare decisis. Then we also have horizontal stare decisis. This is the question of whether or not the Supreme Court is bound to follow its own previous decision, erroneous. Precedent held to the Supreme Court of itself. Now, the Supreme Court has long held that stare decisis is important, and precedent is important, but it does hold the position that it can overrule itself. Now, it'll take the claim sometimes and it'll slap down a lower court trying to kind of work the system here and say, no, only we can do this. So they really assert this kind of hierarchy structure, this vertical structure. And that's how Barnett put it. He says, to begin with, it's important to observe that the Supreme Court does not treat its previous decisions as binding in the same sense that lower courts do, and it never has. It often does it as a political escape mechanism, and it'll use precedent just to kind of continue the process, to not have to change anything, or maybe because they like the political outcomes, but it doesn't treat it in law the same way that they require the lower courts to do so. Now, from this horizontal, so Supreme Court telling lower courts, Supreme Court telling future Supreme Courts that it has to follow precedent, that's the vertical, the two types. Then you can actually have two subtypes of stare decisis and precedent moving towards a way to kind of wiggle through this. And this is Barnett's basically proposal. And he talks about a broad view and then a classical view. And I think the classical view is really very interesting. But the broad view is really how it plays out, at least in my view, in most situations. He says, on the broad view, when the Supreme Court includes a statement in an opinion, and they oftentimes have long opinions with a lot of political opinions, political statements, political questions and answers in there that have nothing to do with the facts of the case itself, but really expand it to a whole different realm. So when they include one of those statements, such as we hold that X, we hold whatever, then now X, Barnett says, is now law for the lower courts. Those political opinions are now law for the lower courts. The broad view, he writes, allows justices to announce rules that go beyond, far beyond the facts of the case and the arguments of the parties before them. Far beyond is my own addition there. The broad view, Barnett writes, treats opinions of the Supreme Court like super statutes. So they can actually create an entire policy directive for the entire system, and then everyone is supposed to follow them. But that really is the system of an oligarchy that we were warned about long, long ago. They treat them like super statutes, he writes, their language to be parsed and applied by lower courts as though it was legislation. The idea of legislating from the bench, they don't call it that. But when they have this broad policy opinion, political opinion, in their legal opinions, they add these long statements, and then the lower courts start applying that as if it was law. This really is a legislative tool from the Supreme Court. He goes on, he says, the stated reasoning, now having precedent, he talks about, is useful, of course. The stated reasoning provided in the opinions of the justices might be illuminating. So it's important to look back on the research that previous justices have done, but their opinions themselves were not binding. He's talking about the early practice of the Supreme Court. He even cites Justice Iredell, who is one of the leading advocates for the Constitution, but actually a pretty good guy, too. He's talking about Chisholm versus Georgia, and there are 4 or 5 dissenting opinions on this. Oh, well, you have Justice Iredell's dissenting opinion first, followed by 4 more. So he's like, this is actually very helpful because you get to understand how they got to their opinion, and they give their actually opinions of how they got from point A to point B. But those opinions are not binding, nor did the founders consider them to be. And check this out. He says, until Chief Justice John Marshall established the practice, there was no, quote, opinion of the court that could be binding. So the founders themselves, up until John Marshall, who was one of the founders as well, he was part of the Virginia Ratifying Convention in the process as well, up until Marshall did this, there was no opinion of the court that could be binding. No one on the original Supreme Court, no Iredell, no John Jay, none of these guys. Just wasn't how it was applied. She says, so at least until then, there could be no canonical, we hold that statements in Supreme Court opinions to be given legislative force by lower courts and then going forward in the future. And that made me think of a great paper that I cited here a while back, sometime over the summer, by Raoul Berger, who wrote Government by Judiciary. He wrote a lot about the incorporation doctrine, which I'm not really going to talk about today. But he cites some of the founders making the case against having the Supreme Court act as legislature. And here he is citing Hamilton, the biggest big government of the time. Maybe Morris and Wilson were bigger government guys, but Hamilton, we all know, was a monarchist, centralizing force, and he wanted more centralizing power for the central government, of course. But he felt constrained to assure the ratifiers. So he's arguing in Federalist 78. He's arguing in support of ratification to a New York audience, and he's assuring them that of the 3 branches, quote, the judiciary is next to nothing. From next to nothing, Berger writes, it is not easy to blow up a conception of judicial policymaking that could displace that of the legislature. He has 2 other ones that I want to cite here as well. Chief Justice Hutchinson of Massachusetts stated in 1767 that, quote, the judge should never be the legislator, because then the will of the judge would be the law, and this tends to a state of slavery. The will of the judge over the supremacy of the Constitution years later. He goes on. This is again from Berger's paper on the Supreme Court as legislature. Such sentiments were made explicit in John Adams's 1780 Massachusetts Constitution, which provided, quote, the judicial shall never exercise the legislative and executive powers, to the end it may be of government of laws and not of men. So when the judiciary, unelected, unaccountable, politically connected lawyers again, when they can actually will their opinion not only on all the lower courts of today, but create that as a policy for all time, then this is a super statute that can only be overturned by a Supreme Court that is generally unwilling in many situations to overturn precedent. Now, Berger, Barnett, others have pointed out ways in which precedent has been overturned, but it is few and far between. And most cases never even make it to the Supreme Court. So in most situations, for most practical application, the idea, if once the Supreme Court sets a new precedent, a new opinion as law of the land, in essence, which it shouldn't be, of course, once it does that, an entire generation, if not generations, will suffer under it. Going further, here again from, this is Federalist 78, again, Hamilton. He's actually citing Montesquieu, the law of the nations. He says, "For I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers." So judging has to be totally separate. It cannot be executive, it can't be implementing law, and it cannot creating law. You cannot have liberty, and that was the spirit of the laws. I'm sorry, not law of nations. Spirit of the laws is where he's saying there is no liberty. And you may feel like you have it today, but they have the power to totally crush it in the future. And here again in Federalist 81, Hamilton again. I like citing Hamilton in these types of situations, even though he was a notorious flip-flopper, which I've talked about. But if he's making the case that this is how it's supposed to be, and people were sold on the idea from the big government guy that this is how it's supposed to be, this is how we should hold the line. He says there can never be danger by judges by a series of deliberate usurpations. What is he talking about? Will judges usurp this power and start legislating from the bench? Well, no, he said the judges could be impeached for, quote, deliberate usurpations on the authority of the legislature. Let's go back to Berger one more time. From his 1979 paper, Supreme Court as a Legislature, he cites Charles Pinckney, who says he was opposed to the interference of the judges in the legislative business. Now, there was a proposal for kind of a judicial council to review legislation, and this was widely opposed. Elbridge Gerry and others, and even people who are cited as kind of supporting it, really not in the way that modern experts and pundits today would like you to believe. In essence, the founders considered the idea, they actually talked about it in the Philadelphia Convention, they considered the idea of involving the Supreme Court in the legislative process, and they said, no, let's just keep it totally separate. We don't want them involved at all. We know what we learned from Montesquieu and others, and then we have these other quotes. Pinckney opposed to the interference of judges in the legislative business. Rufus King opposed judicial participation on the ground that judges must interpret the laws, quote, they ought not to be legislators. We have Roger Sherman. He disapproved of judges meddling in politics and parties. So he didn't like the political process being tainted by judges. And of course, we know that Justice Chase, Associate Justice Chase, was impeached because of the way he treated the Alien and Sedition Acts as a Supreme Court justice. He was impeached successfully by the House. The removal vote, he didn't get removed from office, but there was so much concern about him using that seat as a political tool that after that situation, it changed quite a bit for a long time. Let's go to Elon Werman, also at lawandlawliberty.org. He says, so whence comes the need to bridge the gap between originalism and stare decisis in modern day cases? When did this come up? Why was this a concern? If all of the original judges were originalists, where did it transition to the point where you couldn't actually even look to precedent sometimes? And if you held precedent as binding, you're going to run way off the rails. And year after year after year, it gets further off the rails, further consolidated, more centralized power, as Jefferson warned us would happen in 1820, 1824, and on and on. He says the question, this is Werman again over at Law Liberty, the question arises only because at some point in time, the Supreme Court abandoned originalism and prior originalist precedents and came up with new law altogether. So the notion of requiring adherence to precedent when the Supreme Court has in and of itself over time abandoned the Constitution means you are guaranteed through the court system to have more abandonment of the Constitution no matter what you try to do, no matter what the scenario, really. He says, when precisely this happened is beside the point. It really was over time, piece by piece. We know Jefferson told us in 1790, the ground of liberty is to be gained by inches. We know that the converse is true as well. What we see today, every violation of the Constitution and your rights didn't happen overnight. It was built up on precedent over precedent over precedent, whether it's precedent for the executive branch to exercise more power, precedent for Congress to pass on power to another branch of government, or to pass laws or acts outside their delegated powers of the Constitution, or precedent that the Supreme Court holds that then they force on all the states through the incorporation doctrine. He says, when this happened is beside the point. It surely happened at different times for different doctrines. The point is, once the Supreme Court decided to change the law, the Supreme Court began to reaffirm its changes. So once you have that precedent, and then someone else reads that precedent, builds on it, and then probably expands that or reaffirms it, cements it, and then over time, eventually, you have law by common error, which I'll get to in a moment as well. He says these new legal decisions were now precedents, but they were unlike the older precedents in that they were outside the bounds of permissible textual interpretation. I would just say outside the bounds of the delegated powers of the Constitution, period. Now that brings me back to Barnett. Barnett's talking about the classical view. Remember I was talking about, he said he has a broad view, basically how it's applied right now. If they issue an opinion, they have their political views held as law or as an excuse to hold it as a binding precedent on all the courts around the country. Now he says under this classical view of stare decisis, the holding of a case is the ratio decidendi. My Latin's not good, but that's how I read it. That is the rule that is logically entailed by the reasoning, that's the ratio, that was necessary to decide the case, the decidendi, on the basis of the legally salient facts that were before the courts. So in other words, there is a holding of the case, the ratio decidendi, based on the specific facts of the case. This is the reasoning, he says, that explains the outcome in light of the facts reported by the court. The objective here is for future courts to decide cases with similar facts in the same way. Now, there is something to be said that precedent is helpful when you have a similar case held in the same way over and over. One single time does not make a historical precedent doctrine on its own. And in fact, they need to be reviewed over and over and over. So he's talking about this classical view, the way things actually should be by the courts, by federal judges and justices. He says the Supreme Court clause binds lower court judges to this ratio decidendi of Supreme Court precedents and no more. In other words, the facts before the case, before the court, to decide the specific case, not broader political questions, political opinions, political process, legislation as super statute. The latter is really how it plays out more often than not. Barnett goes on, he says, lower court judges are not required to follow every jot and tittle of Supreme Court opinions. I never heard that phrase. But they are not required to follow every single opinion. They use it as an excuse, and they try to do it whenever it fits their political choices. He says they need only decide like cases alike, and that's in quotes because it's a specific legal doctrine, legal phrase, by following the reasoning that was necessary to reach the outcome on the basis of the legally salient facts. And in essence, we're going back here to... Okay, that loaded. We're going back here to a nice quote that Berger cited in his paper, or a book actually, Government by Judiciary, the Transformation of the 14th Amendment back in 1977. You can read it for free at the libertyfund.org website. I will link to his entire book in the show notes at 10thamendmentcenter.com/path-to-liberty. But he's citing Justice Douglas, 1949, I believe. He says, a judge remembers above all else that it is the Constitution which he swore to support and defend, not the gloss which his predecessors may have put upon it. And that's Douglas talking about the idea that precedent holds weight over the Constitution. It's unfortunate that I think even the ones that talk about precedent being a problem today, they're really on board with this idea of precedent holding weight over the Constitution itself. And Douglas warned about this. It was a reminder. And I don't often cite Supreme Court justices, but this is a really good one. And Berger thought it was good to include again. A judge remembers above all else that it is the Constitution he swore to support and defend. So again, citing the oath. The oath to the Constitution is their job. Their job isn't to keep America safe or to make sure that more people have health care or whatever it may be. That is not their job. Their job is to support and defend and protect the Constitution for the United States. And quote, not the gloss which his predecessors may have put on it. Berger goes on, he says, too much discussion of constitutional law is centered on the court's decision. So when you talk about learning the Constitution, people who go to law school, I've heard this over and over. I still have blood running in my veins, so I've definitely never even touched stepped foot in that realm. Still human, not vampire here. He says too much of this. I've heard from so many people, like, you know, they don't teach you about the ratifying conventions, the papers leading up to the revolution. Never hear about the Articles of Confederation and what the debates were in between the Articles and the Constitution, what the issues at hand were. What they learn is 1803, John Marshall, and forward. So what the Supreme Court said the Constitution means until it changes its mind. That's how people learn the Constitution in school. And we need to learn it a little differently and teach it to people the proper way. So he says too much discussion of constitutional law is centered on the court's decisions, with not enough regard for the text and history of the Constitution itself. It's good that if prominent legal mind was talking about this problem all the way back in the 70s. This is not a modern thing to be talking about, and he was really a trailblazer in this regard. He says we need to recall Justice Gibson's great statement in 1825. And again, another Supreme Court justice, interesting. In questions of this sort, Gibson said, precedents ought to go for absolutely nothing. Precedent means nothing. The Constitution is a collection of fundamental laws, he wrote, not to be departed from in practice, nor altered by judicial decision. And in the construction of it, nothing would be so alarming as the doctrine of communis error. Again, my Latin is bad, but it means common error makes law. The doctrine that just because the error has been made once or multiple times, the idea that just because it's common, it is now law, is a dangerous precedent. He said nothing would be so alarming to construing the Constitution as holding this type of view of the Constitution and the duty of judges, instead of to their oath to the Constitution, holding to communis error. Common error makes law. And he said that is extremely alarming, and it is certainly played out to be that way as well. This is how Barnett sums it up. He says, we must never lose sight of the ultimate goal. And this is just reiterating the same thing now. The ultimate goal, attaining consistency with the written Constitution to which all justices and judges have taken an oath. And I think that is an important reminder. That is the goal. The goal isn't which team is in charge, who does this, who said that, who flip-flopped, whatever it may be. The ultimate goal always has to be consistency with the written Constitution. We're nowhere close to that, of course, because we live under the largest government in the history of the world. So it's not anywhere close. And I would think that anyone involved in any level of the federal government is part of the problem. Barnett goes on, he says, justices of the Supreme Court should be striving to restore the meaning of the Constitution, the whole Constitution. The doctrine of stare decisis is not a justification for their failure to do so. It is an excuse, and I think that he's not pulling any punches there. He can be a very diplomatic writer, but he can be really powerful when he takes a strong position as well. I agree with a lot of things he does, and there's other things where I would say there's probably a tiff of some sort, but that's cool. I think here he's doing really, really a great justice, pun intended, a great justice to the Constitution and liberty, focusing on that oath, focusing on ways to apply precedent in a way where you can still wiggle towards the original meaning of the Constitution, but the reminder, the oath, the whole Constitution, and stare decisis is not a justification, it's an excuse, is a great way to put it. Now here this morning, again, the article that we published by Mike Meharry, I will link to this as well, and I'm just going to a couple of quotes here. He's talking about don't depend on federal judges to protect the Constitution because it's just been a terrible strategy. He's like, they're not committed to your liberty. They are committed to the Constitution. They are mostly committed to precedent, and most precedent is unconstitutional. He goes on, to most Americans, there is nothing more politically significant than who sits on the Supreme Court, and that reveals a big problem. Let me scroll down here. I love how he sums this up. The root of the problem is that so many people, Mike writes, have embraced this absurd system that empowers judges to run their lives. As a result, many will view this SCOTUS appointment as very nearly a matter of life or death. But it doesn't have to be that way. Great job on that, Mike Meharry. I also want to cite, before we head out here today, the episode that I did earlier this year, well, just over the summer. It was in June of this year, June 24th. The Supreme Court issues opinions, not law. I basically talked about this a little bit more, a lot of this type of legislating from the bench. And, for example, Jefferson's warnings that the Supreme Court would be the engine of consolidation, centralization of power, corrupting and influencing the other two departments, leading to, in essence, an oligarchy. When you rely on the Supreme Court or any part of the federal government to determine the extent of its own powers, you shouldn't be surprised when that power grows and grows and grows and grows and grows to points that are totally uncountable, unfathomable. Anyways, I hope you guys found this really interesting. I hope you learned something. It's kind of geeky, heady stuff, but I think it's important to look at the deeper issues, the deeper problems underlying the Supreme Court in and of itself, rather than the political process, which you guys are going to hear about basically anywhere and everywhere you want to look. I want to provide you guys a little different information, and I hope you learned something from this. That's more important than anything. Funky Euphemism says, all con law in school starts with Marbury versus Madison, 1803, of course, and ends with McCulloch versus Maryland. WC says, I hate activist judges, regardless if they're on my side or not. And I would actually just expand that. Activist judges, which we complain about, though I would say all of them, depending on the situation. Some less than others, but all of them out there today. They are activist judges because there are situations where they are applying precedent, even though they believe personally that their oath to the Constitution says something else. The Constitution says something else, so they're not following their oath. They're taking a choice. They're having two options in front of them. Am I required to follow this precedent, or am I required to follow my oath? And I think the oath gets thrown to the side. Taking another look at the live chat here, Jim Knowlton, good to see you. And Dan Warsaw, good to see you as well, buddy. Funky Euphemisms talking about Roe. Oh, here's Austin Thomas. This is good. Very dangerous that both sides treat Supreme Court decisions as unquestionable gospel rather than opinions. The Supreme Court issues opinions, not law. And now, if those opinions based on the fact of the case are applied by other courts on facts of an almost same case, that's one thing. And it wouldn't have the impact that these political opinions having precedent, acting as super statute, like Barnett put it. He says, in public school, we were taught the same thing. They say knowledge is anger. Yeah, no doubt about it. Erwin Havranek says more power for them means less freedom for us. That's my interpretation. Benjamin Franklin said, the courts love the people like the wolves love the sheep. I don't know. Darren DeLeon, that's a cool quote. I've never seen it. If you got a link to that, please post that over on Facebook as well. Darren DeLeon also says, Jefferson said judiciary is the gem of destruction. He said it would be the engine of consolidation. And the consolidation, centralization of power is what Jefferson and other real Federalists, actually people who supported Republican government, federalism at the time, they actually opposed centralization of power in almost every situation. He saw that the Supreme Court already in his time was really acting as that engine of destruction of liberty, of consolidation of the government into too few hands. Well, again, I hope you guys found this interesting and educational. It's more important that you learn something than anything else. I appreciate you being here. If you support what we're doing, you can smash the like button, leave a review on iTunes or any other podcast platform. Subscribe and get bell notifications on YouTube. Leave comments on any platform, live or in the archive. All of these things, all the platforms, the mainstream ones really are very easily triggered. So when you tell the algorithm that you're doing something on the program, the algorithm's like, oh, well, we got to show this show to more people. And it certainly is helping us reach more and more people. If you look at statistics, and maybe sometime I'll do a little behind the scenes video of my setup and some of the stats. And we're definitely steady, slow, but we're consistently growing over time. And I'm very grateful for your help. And thank you to all the members that are out there today. I see a number of them. Oh, yeah. I see a bunch, actually. Pretty awesome. Thank you for putting your financial faith behind our work. And if you are not a member yet, please don't feel obligated to join us. But if you can consider it, I'd be very grateful for any consideration you can give us. It starts out as little as $2 a month over at 10thamendmentcenter.com/members. Again, thank you for joining me today. I hope you have a great Monday, and I'll see you next time here on the Path to Liberty.